for the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Judge, presiding. All persons having been moved before the court shall draw near and give attention, and you will be heard. May God save the United States of America and the State of Florida in this honorable court. Please be seated.
Well, good morning, everybody. Welcome to an oral argument session here at the 5th DCA. I was introduced. I'm Jim Edwards from Seminole County. To my right and your left is Judge Richard Orfinger from Volusia County. And to my left, your right, is Meredith Sasso from Orange County. All cases will have 20 minutes per side for their oral argument. Typically, by default, we put in 5 minutes for rebuttal time. If you want anything different than that, let me know. On our first case, since there's a cross appeal, you're both entitled to rebuttal, or if you'd rather address things straight up, I don't know if y'all had a chance to talk, but in any event, just let me know, both sides, what rebuttal you want. With regard to our setup, if you're not familiar with it, we have a green light, which means you're into your initial time. When it goes to yellow, you're into your rebuttal time. We typically try to let you know that so you can save it. When it gets to red, you're done. And we'll ask you to wind it up, if not stop immediately. If you have any kind of an electronic noisemaker like a cell phone or like an iPad, please either turn it to silent or vibrate, or maybe even better yet, if you don't absolutely have to have it on, please turn it off so that nobody gets interrupted during their presentation. And with that, we will start with our first case of the morning, which is State of Florida versus Scott Frederick Bush, case 183987.
May it please the court. My name is Pam Kohler. I represent the state of Florida in this appeal. I usually keep 5 minutes for rebuttal. I guess I will just address both the state appeal and the cross appeal while I'm up here, if that would make things easier, or however this court wants to do that. The state is challenging the trial court's findings that the allegations, as far as the allegations in issues 3 and 4, that counsel was constitutionally ineffective. In claim 3, the allegation was that the state had tainted the jury by referring to the defendant's employment as a pharmaceutical representative, and that this had become a feature of the trial. To be honest, the record does not support that finding. Number one, you'd have to start with the premise that being a pharmaceutical representative was somehow essentially, prejudicial. And the state basically had argued it solely as it related to count 3 involving DC, the child who had alleged that her father had drugged her, and then in order to take advantage of her and rape her when she was a child, when she was 10 years old.
What is your take on the argument that we would essentially do a 2-layer standard of review, deferring to the post-conviction court's kind of determination that evidence would have been inadmissible and abuse of discretion, and then evaluating de novo the deficiency and prejudice prongs that was suggested in the briefs?
Well, the only deference this court has to give is to factual findings and credibility determinations. Whether or not something becomes a feature of a trial and whether or not something is admissible, this court makes that determination all the time and second guesses trial counsel. Now, I know you make an abuse of discretion determination when it comes on direct appeal, but that's a legal determination whether or not evidence is admissible and whether or not evidence becomes a feature of the trial. So I think that this court can review it de novo as far as those findings, because they were not made by the trial court who actually was at the trial. This is just at a hearing, subsequent. And as far as the count 3 or allegation 3, the state made it clear why they had introduced this evidence, that it had nothing, they weren't trying to say he was a bad person, that he was an abuser, that he was a drug dealer, that he did anything illegal or immoral. As far as because he was a pharmaceutical rep, they were only saying the state is not trying to say the defendant drugged his daughter with the prescriptions that he was selling. The state is trying to say to you that he knows drugs, he had access to drugs, he worked for a pharmaceutical company, and I think he said 3 different companies over 20 years. He understands how they work, he understands what they do, he had opportunity.
What evidence was there that he had, number one, knowledge, and number two, access to paralytic drugs that could bring on the kind of effects that the young lady was talking about?
Well, the argument is he had more knowledge than someone who had never worked at a pharmaceutical company, who had never sold drugs to doctors. I mean, he's certainly someone who had a lot more knowledge than some Joe Schmo on the street. And again, the bottom line is you could...
Wasn't it, I mean, in all clarity, didn't the evidence talk about he knew the drugs he was selling?
Yes. Of course, that's what he would testify to.
And was there any evidence to the contrary?
The state is allowed to draw legal, inferences from reasonable inferences from the evidence, and that was their inference. Obviously, the jury didn't buy it because they found him guilty. He was charged with capital sexual battery, which he would, mandatory life sentence. He received a battery conviction and got a time-served sentence. So how can you show prejudice? Obviously, that didn't bother the jury at all. They weren't tainted in any way, shape, or form.
And was that evidence relevant to any of the other counts?
No, and the state never argued it in regards to any of the other counts. NB never alleged that she had been drugged. There was never any context about that she had been drugged, so no. As far as issue 4, dealing with the motive that the DC had allegedly told the detective that, or actually the agent, that her sisters had no longer, had denied the abuse, I'm sorry. And if you read the transcript, I mean, it's...
Can I back you up a little bit? So sure. The post-conviction motion alleges in ground 4 that the deficiency was the failure to use evidence. What is the state's interpretation of what they were arguing? Was it failure to use the entire interview? Was it the failure to elicit certain questions? Was it the failure to impeach?
Well, the judge just says that defendant alleged counsel should have utilized these statements to show the victims were encouraged to lie about the alleged incidents, as the trial was a credibility contest. That's what the trial court found. And then found that trial counsel was ineffective for failing to call this witness. I don't know what that means. DC was testified, NB testified, CB testified. I don't know what the judge, again, this is another reason why we're challenging this trial court's rulings. Mr. Bankowitz explained that he had made a tactical decision not to even talk about this. And if you read the transcript, I mean, she's crying through the whole transcript. She's about the fact that she didn't protect her sisters, and maybe she should have tried to talk to them more about this, and about how NB had been so traumatized going to the OBGYN because she wasn't a virgin anymore, and she tried to tell her, no, you're still a virgin, that doesn't count. I mean, this is clearly, these children have been traumatized, and that's why Mr. Bankowitz said, I didn't want to go there. In fact, I kept it out on purpose because I saw this as Williams rule evidence that would only bolster their testimony and would make it clear to the jury that they were traumatized by something, and its logical conclusion is they were traumatized by being sexually abused by their father.
Was there anything in that transcript that suggested that she told her sisters to lie?
No, I mean, I've printed it out, and she's asked, she said, I tried talking to her about it. She gets really upset, and she just tells me, stuff happened. But she asked me, if it's possible for something to happen to you not to remember. I'm like, yeah, honey, it happened to me. And, she's asked me, what happened to me, and I've kind of told her, but I don't know. Sometimes I'll feel more strong about it, and sometimes I just don't want to talk about it. So, I mean, the whole thing is, these...
I mean, I can see in fairness where somebody could argue, well, maybe the sisters didn't really remember, didn't recall. I think it can be read differently as well, but I didn't see anything in there where she was encouraging the sisters to lie. I know there's a separate allegation about the son saying the mother encouraged them.
Correct. And, I mean, the fact that, according to the agent Duncan, when he talked to NB, she told him the same allegations she had said back in 2009 when she went to the youth resource officer at school. So I don't know that this, I mean, and if it could have been used to benefit the state, and that's why I argued, at best it might have, hurt their test to a certain extent that they didn't want to remember, but then the way to have used this was not to get it out through DC. It would have been used to use it to get it through NB's testimony, cross-examine her and ask her, well, didn't you basically say you didn't remember this? And then she's going to say, well, yeah, but only because I don't want to, because it's so traumatizing for me. I mean, he's like, I don't want to get that out. So I don't understand how the trial court made the conclusion that either one of these showed that counsel was constitutionally defective.
Was there anything in that transcript indicating the time that those, or the, the year, the time frame that those conversations allegedly occurred? So, when she would have been having the conversation that, is it possible to remember this and that sort of thing? Is there anything linking that to either before the investigation or after?
The assumption was that it was because they learned that the investigation had been reopened. And that's why DC had approached her sisters about it, or discussed it with her sisters. But she never specifically says that, but that was the assumption made by everybody. And of course, NB had made her allegations in 2009. This was like 2010, I think, the phone discussion. So, and then she testified consistent with her allegations in 2009 when she testified at trial in 2013.
Yeah, I think I had that the interview would have been in 2011, and the allegations, the initial allegations would have been in 2008. That that's the ones that she would have been helping her remember. So I was trying to see if there's anything in the transcript to suggest that conversation happened before 2008 when those initial allegations were made.
No, again, there isn't. And the fact that they talk about her going to the OBGYN, I assume that didn't just happen since they announced they were reopening the investigation. So obviously some of that had to do with beforehand. But again, I think the transcript just reveals 3 young women who were having trouble with the fact that they were abused by their father and wanted to forget it, basically. I can go on to issue 1, having to do with that the trial court found that trial counsel was more credible than SB regarding that his mom had told he and his sister to encourage them to lie about sexual molestation. That was back in 2003. Obviously, NB did not come forward until, and in fact, when she was asked in 2003, she denied that there had been any kind of abuse, and that's why the DCF had closed it against her and her brother, SB, and only DC was the one who was eventually flown out to California to live with her mother. So, and it was obvious, too, that SB was very angry with his mom. He testified at trial that he didn't want to have contact with her. She couldn't even provide one single present, whereas his dad provided him all these cool presents, gave him anything a kid could want. She abused me. He referred to her as a witch. So him coming forward and testifying at that trial that, in addition to the fact that NB had discussed with the fact that she wanted to go live with her mom, so she was going to make allegations of sexual abuse with her dad, which is what he testified to. In addition to that, mom had encouraged us back in 2003, which she never alleged that there was child abuse. Oh, and by the way, yeah, we've been told that, and we both said we weren't going to do it. So I don't know I don't see how it's either deficient or prejudiced, but of course the trial court found trial counsel was more credible, that SB never told him that, and in fact denied that his mom had told him to lie about this at that time. And again, he had told, if you look back at his 2003 interview that is contained within the record on appeal, he basically said that his mom had asked him to say that, to tell people that his dad was abusing people. Nothing about the fact that his sisters were around at the time and responded, and that he told his mom, "Oh no, I'm not going to do that because I love him too much." So, I mean, I don't see that that's a real issue. Issue 2 is also credible determination and a strategy issue. Whether or not DC had recanted. Apparently there was no formal recantation. Apparently all the paperwork from DCF doesn't contain any formal recantation. The only reference to that was during Helen Bernstein's deposition prior to trial, that, oh yeah, back in 2003, she had heard that the victim, DC, had recanted. Of course, DC had been deposed prior to trial, and she categorically denied that she had ever recanted. So when the defendant testified, of course, and claimed that he had heard that she had recanted, I mean, yes, he had heard it, but I don't see that there was any evidence he could have presented to substantiate that fact. And the thing to have done was to basically ask DC, did you recant? And of course, she had already denied it in her deposition prior to trial, so you would not have accomplished anything. But again, the trial court found defense counsel more credible and that his strategy was reasonable in not pursuing that testimony from Ms. Bernstein. Again, I don't know how you get in the deposition. When you talk about opening the door, you generally, you elicit some testimony during direct or cross, and then the state or the defense is allowed to come up on cross or direct and redirect and say, oh, well, isn't it true such and such and such and such? You don't get in a deposition of hearsay from the woman saying, well, maybe it could have happened, but well, that's what I heard, but that's all. She never could testify that she actually heard or saw a recantation. So again, I don't see that the trial court properly found the defense attorney was credible in both of those cases, the more credible, and properly denied those claims. And then I've got 6 minutes, so I'll hang on to that. Thanks.
Good morning. May it please the court. Lauren Roten on behalf of the appellee and cross-appellant Scott Bush. With regard to the issues that have come out so far, the court granted relief on grounds 3 and 4 of the 3.850 motion. Ground 3 having to do with the comments about the pharmaceutical representative position. It's not merely that the state pointed out that he was a pharmaceutical representative. And this is what the lower court looked at. They said there was a multitude of references to his job. And it's not just that he was a pharmaceutical representative, it's the way that it was presented against him by the state. They referred to him as a pharmaceutical genius. They implied that he had access to medications. They implied that he had this encyclopedic knowledge of pharmaceuticals. None of this is borne out in the record. And as was demonstrated at the evidentiary hearing, Mr. Bush...
I mean, the genius comment wasn't borne out in the record? Wasn't that on testimony from his coworker?
The genius comment was. The genius comment was, it was brought out by a witness on the state's cross-examination of him. But in terms of Mr. Bush having access to medications other than the ones that he represented, the representations that he had this encyclopedic knowledge and he knew drugs and he had access to them, none of that was proven. It was.
But where's the actual prejudice? I mean, if he had been convicted on the capital sexual battery of the daughter who claimed her ice cream had been drugged, then it seemed to really tie together well in terms of saying, well, this is how my client was prejudiced. Since he was found guilty of simple battery on that, talk to me about that.
I understand the court's position on that or statement on that, but the thing is, we're looking at perhaps the jury didn't find that it was proven beyond a reasonable doubt that there was a sexual battery there. They might have looked at it and said, this probably happened. Probably is not beyond a reasonable doubt, but it's a preponderance of the evidence, and if the jury, and we don't know, that's the problem. We don't know what the jury exactly thought.
But isn't that the problem with our standard of review? Because we're looking at whether there's a reasonable probability that the outcome would have been different, in terms of prejudice. And what is there in this record to suggest that the outcome would have been different, that there's a reasonable probability other than perhaps or maybe?
Well, the multitude of, as the lower court said, the multitude of references and the way that it tainted the jury. Although they might not have found him guilty on that, like it's different standards. And it's possible that they thought he probably did this. Probably isn't enough for that count. But when we have a credibility contest, because that's what this was, it was a credibility contest between Mr. Bush and his daughters. There's no DNA, there's no physical evidence, it's his word against theirs. When we have that kind of credibility contest, any little thing can start shifting the scales. And if we have a jury thinking, well, he was this pharmaceutical genius and he probably drugged and raped his daughter, a horrific allegation, maybe they thought, well, it wasn't proven in that count, but at that point it starts tipping the scales. in terms of their credibility, and that's where that prejudice comes in, is everything he needed to be believed, he needed to discredit them. That is a way of discrediting him by making him look bad. Whether it actually was enough to prove beyond a reasonable doubt on that count, it certainly was something that the jury was hearing. It certainly, I would suggest, it certainly is something that, had it been objected to, the court would have found it to be inadmissible, because there was no link between Mr. Bush's profession and a proof of any access to medications, a proof of any knowledge about anything. And it's just such a horrific allegation to make that we don't know what it does to a jury, but it certainly, I would suggest, as the court found it inadmissible, we know that it's problematic. And that's the reason it would be, because we don't want to have to make those kinds of determinations later on. Is this going to be something we have to guess? Did this prejudice them or not? We can't know for sure, but there was an awful lot there. And
is it your position that in any case that that evidence would have been admitted, it would have been an abuse of discretion for the jury, for the trial court to have made the determination that the jury should be allowed to hear that evidence?
I'm sorry, my ears are clogged up.
Is it your position that every time, in every case, if a judge allowed the information about his prior occupation, or his occupation at the time, that it would be an abuse of discretion for the jury to hear that? No,
not in every case. However, in this case, it was the implications that were made from that are the problem, okay? If there was just a mention of, oh, he's a pharmaceutical rep, there wasn't just a mention, though. There were approximately 33, I went through the record, there were approximately 33 references to pharmaceutical rep, drugs, medication, and all in reference to this issue of him drugging his daughter. It took up approximately 5 pages of the entire, this was not just a mere mention, this was a repeated, they hammered on it. And it's...
And so in your view, no reasonable trial court in the state would allow that information?
There was no link between his profession and access to medications, and that's exactly what the state's position was. He had access to medications, he had the knowledge. None of that was borne out in the trial transcripts, and at the evidentiary hearing, we actually showed very much to the contrary. He was a guy who had a little training book that told him about the medications that he had. The access to the medications, he testified that they were highly regulated. He had to account for everything that he was distributing, and none of the medications were ones which would paralyze or render somebody unconscious. So I'm not sure if there's any other questions on that.
No, you can go
okay,
ahead.
with regard to issue 2,
can you go to ground 4?
Or ground 4, excuse me, yes. Sub-issue 2 of sub-issue 2 of the state's claim. Ground 4. Our position there is the recorded statement, the entire thing was not necessarily admissible. However, the defense's position, as was argued by Attorney Bankowitz, was this was something that was orchestrated by, that there were, by the mother, but also we see that there were, it could have affected DB. And she's making statements in there that she's talking to her sisters, asking them.
So what, in your view, is the specific deficiency that occurred in this case? The motion just says use.
Right, and if I had written a proposed order on that, I probably would have been a lot more specific than the lower court was. However, my position is the deficiency is when DB was testifying, that could have been brought out, that she was speaking to her sisters and trying to get them to say something because they were saying, no, I don't remember anything, it was a long time ago.
So it was the failure for counsel to ask DB a specific question?
It could be to ask her on cross-examination or to move to admit that specific excerpt. It doesn't,
And so where in the proceedings below is that specific deficiency highlighted? Because I think the Supreme Court case law does tell us that, it's incumbent on the moving party to identify a specific deficiency that basically rendered the defendant without counsel.
Well, and I think we did that in the initial brief, but...
but we're reviewing
of course,
the lower court's decision.
Of course. And like I said, I I looked at the lower court's order on that, and I wished it would have been more specific.
Well, and I think the lower court was basing the order on the motion, and as.
Correct, and they
as that
did
was
give a
put.
recitation of the allegations that we made, and then came in and said, okay, relief is granted. But the specific inefficiency or ineffectiveness there is the failure to bring that out. Counsel knew that these comments were made in the recorded conversation, and never confronted DB with that.
Where was there anything to suggest that she was encouraging her sisters to lie? Again, that's what I asked the state, and then I'm going to ask you the next question too, but deal with that one. Tell me where in that transcript of the interview there's anything that you can fairly read as the sister was encouraging her other sisters to lie.
Okay, well, and there was not a specific statement, I asked my sisters to lie.
Right.
That's not in there, and I wouldn't suggest that.
Well, but that's what the trial court found.
However, you can draw inferences from her comments where she's asking them, she's telling them, well, it happened to me. You know, when NB is asking her, is it possible that something happened and I don't remember? She's saying that she's asking that. DB is essentially trying to influence her and saying, well, it happened to me. And, you know, that's the kind of thing where we know witnesses are suggestive. We know that witness testimony is never perfect. Memories are not perfect. And when you have somebody, especially a loved one who's there, suggesting, well, the same thing happened to me, it must have happened to you. I mean, that's the inference to be drawn. She didn't use those words.
And I understand, you know, again, now I'll take you to the trying to get them to remember, or words to the effect that the sisters did not remember as opposed to did not want to remember, which is what trial counsel had in his head, that perhaps nuanced difference. Talk to me about that a little bit.
Well, trial counsel admitted at the evidentiary hearing that he really didn't have much of a memory about that. He said, I gave all that away. I don't really remember. So a lot.
That's a tactical decision, though, right?
Excuse me?
In the evidentiary hearing, trial counsel did express what he viewed as a tactical determination.
He did say that it was a tactical determination, in part because he prevented the admission of that recorded statement, and there's nothing in the record aside from his allegation there that I've been able to find where there were any motions to exclude that. There's nothing that I saw in the trial transcripts where he moved to prevent the state from dealing with that.
He mentioned that, but he also mentioned the idea of not cross-examining them on that because it, you know, draws out, like we said, the traumatic events and why aren't you remembering, that sort of thing. That would be a tactical reason, not.
Well, and once again, the ineffectiveness there is the entire recorded statement did not necessarily need to be presented, okay? It's standard that if there are matters within documents that are inadmissible or prejudicial, it gets redacted. And our suggestion is he could have kept it very limited to those statements. There are a lot of other statements that were in there that would be prejudicial, but they don't necessarily relate to DB's comments about my sisters told me they don't remember, I'm trying to, you know, that kind of thing.
And going to prejudice on that, it seemed that the defense theme throughout was the idea that this was coming from the mom and that the sisters were saying this so they could move to California. I mean, that's in opening, it's in the cross-examination of the sisters, it's in SB's direct, it's in closing. So the state alludes to this in their brief, but if that argument had come out that these were ideas that were being planted rather than, you know, by the sister rather than the mom, how would that have been consistent with the defense's theme? One
doesn't necessarily exclude the other. We can have the mother trying to influence them at one point, which was earlier on. According to SB's statement, that was back in, I think, 2003, when he says the mother was asking us to lie against our father and say that he raped us. And then DB's statement was in 2018, once this, or not 2018, 2013, I think, once it started getting investigated. And they're not mutually exclusive things. We could still have the mother trying to convince them at one point. Perhaps she, the allegations were made by all the girls, so under that theory, they went along with what she was trying to do, under the defense theory. So it makes absolute sense that she would still, that the sister, DB, would still be going along with that and also trying to convince the others to go along with it. I mean, they're not mutually exclusive. If she says it, then the mother didn't. They can both have occurred.
And does that create a reasonable probability that the outcome would have been different in this case?
I think so, if the jury's hearing that she's influencing them. I mean, that, as you stated, it was all, consistently throughout the trial, there was the theory that these were allegations that were made up because the girls wanted to go live with their mother in California, that the mother had orchestrated it, and these were common.
The jury heard all that and presumably rejected it. So I
Well,
guess the question is, why would the admission of maybe one more statement from DB that she might have influenced her
All of this
sisters?
ties in together. As I explained earlier, everybody agrees it was a credibility contest. Defense counsel agrees, the trial judge Adams, or the evidentiary hearing judge Adams, everybody agreed this was a credibility contest. So we have to start looking at what affects the credibility. That's one thing that affects the credibility. What affects the credibility? Attacking Mr. Bush on the pharmaceutical rep and making him look like a person who drugs people and rapes them. When you start looking at credibility like that, we've got a scale here. You start throwing things on that start affecting and tainting the jury about one side, it starts affecting that. And there, like I said, there is no physical evidence in here. There's no DNA, there's nothing. It's words coming from
But should
people.
we assume that once, assume you got the transcript, that little portion that you really wanted in there, are we to then presume that nothing would happen after that, like the sisters would be brought back on in rebuttal and say, no, she didn't tell me to lie, no, I didn't tell him to lie, I didn't want to remember it, I mean, or...
We don't know what they
ignore
we
that?
don't know what they would have said.
But
To be fair.
given them what their testimony was, and especially DB's denial that she ever recanted and denial that, mom told them to lie and all the rest of that, I mean, it's not like we've got something out there for sure that was kept away. I mean, it's a possibility, it's one reading.
It's one more thing, and I think it all is important. It ties in, and if it's okay, I'd like to move on to the last two issues because I'm running short here. With regard to issue number 1 of the 3850, which is ground one of the cross appeal regarding to SB's statement. There's a finding that it was a strategic decision on the part of counsel. I would suggest there was an abuse of discretion in this case in finding a strategic motive there.
But aren't you really asking us to reweigh the credibility?
And yes, and I understand that abuse of discretion is a very high standard for us to overcome. However, testimony that's inherently unreasonable or unbelievable can be rejected by the court on appellate review. I would suggest that Mr. Bankowitz's testimony was heavily impeached. There's nothing, when you look at SB's statements from the start where he's saying, he says, my mother asked me to lie. That's what they have in Jeffrey Duncan's. Once again, that does not exclude, we don't know, maybe they didn't ask him, did he ask your sisters to lie? There's not anything where he says that they didn't, but he's been consistent from the start. The mother asked for a lie against the father about the daughters being raped. That was way before trial. That was before Mr. Bankowitz.
The fact that what Bankowitz said may not be predictable in a case like this doesn't mean it didn't happen, and the trial court was basically, or not the trial court, the post-conviction court was faced with, well, it's hard to believe, but yet he's saying that, and I believe him. Who are we to come along and go, no, you're wrong?
I would suggest if you look at all of the evidence there, the consistency from SB from the start all the way through to the evidentiary hearing, he's been consistent and insistent that this happened and that he was willing to testify against or testify about it. Then you'd have to look at Bankowitz's testimony. He doesn't have his files. He doesn't remember a lot of things. He says whatever fits what he's trying to say. He claimed that there was no recantation, but at trial, he mentioned numerous times in the closing argument, there was recantation, DB is a liar. Those are all specified in the brief. There was a lot there. He knew there's a recantation, but at another point he's saying there's not. He is not consistent. He has no memory of the files. It's not believable. It's inherently incredible and unbelievable, I would suggest. And that's why I understand it's an exceptional thing that I'm asking for the court to reweigh that testimony. However, under those circumstances, I think it's justified. And when you look at that, this all ties in, once again, credibility. And once you start being able to chip away at it and showing, hey, here's things that happen, it starts to support Mr. Bush's defense and starts to chip away at the state's case. Defense counsel dropped the ball on a lot of different aspects on this, and it's at this point, I would suggest all of these tied in, the ones that were granted and the ones that weren't. When one looks at all of those, it's very clear that there was ineffectiveness of counsel and that it essentially deprived Mr. Bush of a defense. He had no defense when he went before the court or before the jury. And I have no rebuttal, so thank you very much.
All right, thank you.
Just going as to claim 2, he talked about the fact that, claim 3, I'm sorry. Again, it's my conclusion that based on what he's arguing, all his claim of ours tainting the jury is all speculative. And this was a reasonable inference, and as far as that the jury could conclude that that somehow they were tainted by the fact that he was a pharmaceutical rep. Again, he argues that it's how the state addressed it. But the state, even in their closing argument, they only talked about it once during their initial closing and once during their rebuttal. And they made it clear the reason why they were referring to it, and it's just that, hey, he had access to drugs, he had knowledge about drugs, more than your usual guy on the street. And again, no prejudice because the jury found him not guilty of capital sexual battery, and guilty only of battery. The recorded statement, of course, they were claiming that DC lied. She could have been lying about what she said on that statement to Agent Duncan. So again, it's speculative. They're wanting to believe the part that supports their case, but not to have the jury believe the part that did not support their case. Again, and then the state, obviously, as you pointed out, Judge, that once they got that introduced, they could have called the NB, and of course, at minimum, maybe introduce her prior consistent statement that she tested when she gave her statement back in 2009, 8 or 9, when she went to the youth resource officer, that she had said the exact same allegations that she testified to at trial. So, and then again, she would have said, oh, I was so traumatized by this whole thing.
What about the fact on their cross appeal, the son was very consistent in saying, Mom wanted us to lie, Mom told us to lie. Can we look at that consistency and say, well, the attorney's testimony doesn't make any sense, we're allowed to discard that and change the credibility analysis?
No, I mean, the trial judge was there and saw these witnesses testify and found the attorney more credible than SB. And just because he's been more consistent, but again, SB is very biased for his father, has always wanted to help his dad. So the attorney, I think he was pretty good at explaining things, considering he hadn't had his files since the appeal was final. As far as, it's not like he just said, no, I decided not to do that. I mean, he explained, look, I would mention it, the defendant would say, no, that didn't happen, and would interrupt SB. So I asked, to speak to SB by himself, and I saw him for several hours by himself, and each time he would say, no, Mom never told us to lie about this. So it's not like he just said, no, that never happened, that I was never told this, or SB never told me. He explained, no, in fact, he didn't tell me this. This is what happened. When I would mention it during conferences with my client and his son, the client would say, no, that wouldn't happen. And then I talked to SB on his own, and he confirmed that that did not happen. So this isn't just a simple case where the attorneys just say, no, that didn't happen. I mean, I think he gave some really good explanations as to why he did what he did. And this is one example of it. As far as the recantation that they were talking about, again, there was no recantation, and the defense attorney explained why he said that, what he testified the way he did. He said, well, at the time in 2003 when all this happened, it was not his understanding that there was a recantation. He never heard anything about a recantation. When he didn't hear anything about it until prior to trial for these charges, and then apparently HB had mentioned Helen Bernstein had mentioned the fact that she had heard that there had been a recantation, and then the defendant testified. So of course he's going to argue in closing and hit it hard. Recantation, she's a liar. Recantation, she's a liar, and he did. But again, he's saying just because he testified, that there was no recantation, it was not his recollection that DC or DB had recanted back in 2003, just that that's what his client had testified to during the trial, so that's what he hammered on in closing argument. That's totally reasonable. So again, I don't think that there's any basis to not find his testimony credible, and especially the trial court correctly found him to be credible on those issues. And this court has no further questions? I'll rely on my
Thank you.
brief. Thank you.